not sure which one's live, but. All right, it is time now for convening the Senate committee. That is Select Committee on Investigations. It's been duly noted and posted and advertised, and all committee members have been notified. So I hereby call us to order for our inaugural organizational meeting. Thought I would make a few comments to let folks know where our authority comes from and what the mission of this committee will be. I give my thanks to the Vice Chairman, Senator Greg Dolezal, who introduced Senate Resolution 465 earlier this session. And it brought attention to the fact that there has been a lot of recent publicity and court filings concerning Fani Willis and her personal conduct, including certain allegations of potential improprieties as well as significant expenditure of public funds that have been called into question by a number of people, both parties in some of the pending judicial actions, as well as by the Atlanta Journal-Constitution that's been doing very thorough investigative reporting. The resolution that was adopted by the state Senate, Senate Resolution 465, asked the formation of this committee and asked us to do some independent investigation to look into this potential misuse of public funds, prosecution for personal gain, any violations of certain proprieties and conduct in a public administration. I want to make a couple of things clear up front. It is not the charge of this committee. It is not within our authority or our scope to disqualify counsel in any ongoing criminal investigations. It is not our charge to criminally prosecute anybody. That is beyond the scope and authority of the state Senate. It is not part of our job to disbar anybody or to bring professional allegations of professional misconduct against anybody. It is not the charge of this committee to in any way interfere with any ongoing criminal prosecutions, and that is not where this committee will go. Our job is to investigate many of these troubling allegations that have come forward in the last few months, determine what the true facts are, independently investigate and verify the truth facts, and to shine light on these facts, whatever they may be. The more specific charge of Senate Resolution 465 is if we need to amend existing laws or pass and create new laws to restore the public's faith in the impartiality and fairness of our criminal justice system, we will be looking into those options. And to consider the current and potential future both state and other public funding of certain activities of district attorneys throughout the state. We are not trying to supplant the new prosecutorial commission that is established to look into prosecutorial misconduct. That will run parallel with us and independently of this committee. What we really want to do is find out the facts. We're not here to accept as face value anything that we've read in published reports up until now, but a lot of very troubling allegations have been raised, and we want to independently investigate that. There have been questions asked about whether or not the Senate and this committee individually have the authority or the ability to conduct such an investigation. Investigations are part of the inherent power of the legislative branch, and we've seen them for centuries. Certainly in the United States Congress and in most other states, they are routinely performed. In order for us to do our job, we have to find the facts. We do that through public hearings every time we pass a bill in this body. We are also given power to conduct investigations under Official Code of Georgia 45-15-17 and 45-15-19 that very clearly grant the power to the General Assembly to conduct investigation, including the issuance and enforcement of subpoenas, both to compel testimony and to obtain documents and things that are significant in the course of the investigation. This has rarely been used by the state Senate, but it is authorized if we pass a resolution defining the scope of the investigation and giving the charge to a special investigative committee. That has been done. There are extensive legal memoranda that have been prepared by our Legislative Counsel's office, by the Secretary of the Senate's office, and our own legal research that validates the authority for this committee to operate, including having sworn testimony under oath, and subpoenas for documents, for things, and subpoenas compelling testimony. We anticipate we will use all of these devices in the course of this investigation, and we will certainly be willing to enforce, ready to enforce our subpoena power in court if necessary, if individuals or organizations refuse to comply with valid subpoenas. I have had lengthy conversations with all members of this committee. We were only recently appointed by the Committee on Assignments, and I had particularly spoken to members of the minority party. The minority leader, Ms. Butler, is a member of this committee and is a friend of mine and very well respected throughout the legislature for her experience and political savvy and her integrity in the legislative process. I was also excited to see that the minority whip, Senator Jones, is a member of the committee. He has more experience than probably most of us put together on this committee, having been a prosecutor and elected solicitor previously in Richmond County. He understands the criminal process, investigations, subpoenas, and it was very important to me that he have faith in the bipartisan nature of this committee and the impartiality that I intend to pursue in the leadership of this committee. Likewise, Senator Estevez is an extraordinarily gifted intellectual attorney who will be participating in this committee, and he and I have had conversations. I have assured him as well that this is not going to be a partisan process, that we have both parties included in this committee for a reason, and it's important for our validity that the public understand that this is not any type of political witch hunt. This is a quest for the truth, and we're going to use the tools available for us. I appreciated Senator Estevez's kind comments on lawmakers the other night, that he has confidence that we will run this committee appropriately. In that sort of tenor, we made certain as we were getting organized here to try to come up with procedural rules that we're going to follow, that all parties, all members of this committee can agree to. And these rules that we will be presenting here shortly today have been circulated amongst all committee members for input, feedback, and have gone through several iterations. There are 3 specific requests of the minority party that were discussed with me, and all 3 were accepted and built into these rules. For example, Senator Jones made an excellent point that in the event we take depositions, it is likely that I will be conducting the deposition, or perhaps outside counsel, more skilled than I in that regard, may be asking the questions. And Senator Jones said, well, wouldn't it be fair to allow the minority party to also have a representative asking questions? And I concurred with him completely, and we built it into the rules under depositions that upon request of the chairman, I will grant the ability for one minority member of their choice to participate in any deposition that we might take. I thought that was a reasonable request, and that was certainly fair. Another request was made that in the event we form subcommittees, and we have the authority, the ability to do that, to expedite our work, that any such subcommittees will include at least one member of the minority party. Again, an extremely reasonable request, and in the spirit of bipartisanship, I have implemented that into these rules. He had a couple other notations or changes in the rules that helped improve them. And so I just want to assure the public that this is a bipartisan panel, and we will be proceeding in a nonpartisan type manner with no intention whatsoever of interfering with the criminal justice system. Any ongoing prosecutions or investigations will not be interfered with in any way by this committee. Now, there will be sensitive matters that will be considered by this committee. We've already had a number of people reaching out to us in the nature of whistleblowers, basically people that have sensitive information that they think might be of interest to this committee. And we will have the ability to have some meetings that will be confidential to protect those type of sources. If agreed upon by the committee, that we will have some things that will not be public. There will be a lot of information that is accumulated by this committee. Some of that will be of sensitive private nature, and in our discretion, we may preserve the confidentiality of that. Any information we receive will be available to all members of the committee to review and evaluate during this process. We do not know how long this will take. We are not going to be rushing to judgment in any way. We're going to be deliberate. We're going to be thorough and sifting in our evaluation of evidence and information that may come before us. And I'm going to run through the rules that are being proposed here today very quickly, and I'll answer any questions that any members may have, and then hopefully we will be able to reach a consensus and agree on the rules and procedures and processes that we'll follow in the course of this investigative committee. At the conclusion of our meeting, once we've done our organizing here and agreed upon the official rules of the committee, I'm going to open it up to all members of the committee if anybody would like to make any public comments or statements as to their participation in this process and their views, their observations of it, or their dreams, hopes, and wishes for how we will proceed, in case anybody would like to make any comments. Each of you will have before you the proposed rules, and I'll just run through them very briefly. There are these 9 members of the committee, and a quorum will be 5 members. We'll have to have the majority of this committee to form a quorum, anything we're going to take official action on. On the other hand, in the course of this investigative committee's work, we may be taking testimony and receiving evidence from numerous individuals and sources. We will not require all 5 quorum to be present for accepting such receiving evidence, but at least 2 members will be required to be present at any time we are receiving testimony or evidence. The chairperson will be authorized to schedule the meetings of the committee, but notice shall be provided to all members at least 24 hours prior to any meeting. It is my practice and my desire that we will have much more notice than just 24 hours, but sometimes things have to happen quickly. We will have meetings that will be convened, recessed, adjourned, scheduled at the order of the chairperson, or the majority of the committee will be able to do that as well. I'll schedule the agendas and the order of business that we'll conduct. We will allow public comments to be heard on issues before the committee on most occasions, but not always, and we may limit the time for public comments. I do not intend for this to become any kind of public media circus. We are serious about the business we're conducting. We're not doing this for publicity. It's being done to investigate some very serious allegations. We will have minutes kept of all the proceedings. The Secretary of the Senate is taking minutes for today's meeting, but we anticipate that we will have staff on the committee that will be subsequently approved, and we'll have an administrative assistant tasked with that job of keeping minutes of our meetings so that they will be open to the public. We will follow the Senate rules, and Senate Rule 1-5.1 requires our meetings to be open to the public unless a majority of our quorum votes to have a meeting or parts of a meeting or hearing closed to the public. There are specific rules in the Senate rules that provide for closed meetings, particularly when investigating allegations of public corruption or individual conduct that might be sensitive in nature. So we will have that option available to us. Rule number 3 gives the authority to set up subcommittees. We may need to, for any kind of investigation, study, or research, find that we're more efficiently run if we designate certain matters to subcommittees. And at Senator Jones' urging, I have agreed and think it's fair that any such subcommittees will have at least one member of the minority party participating on that subcommittee. Any materials that are obtained by these subcommittees are going to be submitted to me upon completion of the subcommittee's works, and they will all be available to each and every member of the committee and our committee staff. Sometimes these materials may be confidential and will stay confidential in accordance with the committee, the rules of the committee, and my direction, but they will be made available to members of the committee for inspection. Rule number 4 deals with confidentiality, and it just points out that from time to time we're going to be seeking information that's confidential in nature or privileged or maybe not even subject to open records requirements. And these things in such a sensitive nature, it may be not in the public's best interest that they be disclosed. It might actually impede or limit our investigative success if they're not agreeably kept confidential. So we will be allowed to designate documents, testimony as confidential from time to time, and may very well do so, particularly upon request from somebody that we're asking to testify before this committee. If they prefer confidentiality, we will be likely to grant that. Anything that's presented at a closed meeting of this committee will be deemed confidential unless we otherwise undesingate it or allow it to be made public. And here under 4C, I make it clear once again that each member of this committee will have access to all of this confidential information and materials. Nothing will be concealed from committee members, although we may prevent the unauthorized disclosure of this confidential information. And members of the committee are reminded that if something is deemed confidential and it is received by us in a confidential nature, or confidential documentation is reviewed by our members, that we will be bound to keep it confidential. And finally, if there's any breach of confidentiality, we can refer that to the Senate Committee on Ethics for treatment under the Senate's rules on ethics. So in other words, members of the press that are here, do not be expecting a lot of leaks from this committee. If we're receiving matters in confidence, we will be maintaining that confidentiality. Number 5 reiterates our authority to issue subpoenas, writs, and warrants to compel testimony and documentation that we might request. The process will be that any subpoenas, writs, or warrants will be signed by the President of the Senate, attested to by the Secretary of the Senate, and that is after either the chairperson or the majority vote of this committee agrees to issue such subpoenas. Number 6 deals with testimony under oath, and it makes it very clear that the chairperson or anybody else designated by me can administer the oath, and it cites the relevant code sections for the rules of evidence and civil procedure that allow for testimony to be received under oath. I think it's important when we're asking important questions and information from this committee that we get sworn testimony, that we can rely upon the veracity of it. Number 7 deals with depositions, and it allows both the chairperson or private counsel for the committee to take depositions with or without other committee members and staff present. But as it reflects there, if anybody any member of the minority party requests to participate in the taking of the deposition, either from simply being present to observe and listen to it, or to participate in the question itself, I will permit that. All these depositions will be taken in private, and they will be taken under oath unless we specifically move for them to be public. Witnesses that may be deposed or questioned by this committee will have the right to personal counsel that will be able to be present with them at any such deposition. They're just to advise them of their rights, but not to coach the witness in their questioning. There may be objections that are raised as to questions or to the responsiveness of different answers. The chairperson shall be allowed to rule upon those objections, and the entire full committee can appeal any rulings of the chair that are questioned. As chairperson, I will consult with a member of the minority party prior to making any decision about the public release of testimony after it has been obtained by this committee. Paragraph 8 deals with the staffing and resources of this committee. We are going to need to secure appropriate administrative and professional staff to help carry out the duties of this committee. That might include outside legal counsel, it may be counsel here from our legislative counsel's office. Stuart Morelli is present today, and I think he has been designated by legislative counsel to be assigned to this committee. We will need an administrative assistant, potentially investigators, legal research assistants, certainly a court reporter, and there may be other necessary staff. Any such staff is subject to the approval of this committee, and any administrative and staffing expenses will be subject to the approval of the Senate Committee on Administrative Affairs. Number 9 there is for expenses that again recites that those are subject to the approval of the Committee on Administrative Affairs, and lists the types of expenses we anticipate that we may incur. Number 10 is getting really to the core of our mission, is in the Senate Resolution 465. It calls for this committee at the conclusion of our investigation to issue any report and recommendations that we may agree upon, and that those will be in writing. They'll be prepared at the conclusion of our, or even possibly during the course of our investigation. Any member of this committee that disagrees with the proposed report will have the privilege, the authority to file a minority report that may differ in its finding on what the committee as a whole decides. And as a catch-all here on number 11, the rules of procedure, if it's not specifically in these rules, we will follow the rules of the Senate that have been agreed upon for this biennial. And finally, number 12, these rules may be amended at any time upon a written request to do that, given to the chair at least 72 hours before us considering a change, and will require approval of 2/3 of the member of the committee. I think that's a pretty thorough explanation, but we are in a little bit of new territory that we haven't exercised our rights of investigative committee recently, so I am certainly happy to hear any questions from committee members about these rules at this time. I want to thank each member of this committee for taking the time to hear me out, not just this morning, but before today, as we created these rules and for your very valuable input. I've already noticed maybe a couple of little typographical glitches in these that we may clarify here as we proceed. And I am very thick-skinned. I will not get my feelings hurt if you have any constructive criticism of these or proposed changes at this time.
Chairman, I'd like to ask a question.
All right, I have a question from our majority leader. Make sure I got your right number.
I think I'm to your left.
That is it.
You had it. Thank you. First of all, I want to thank you and the committee members for taking on this responsibility and this opportunity to seek the truth. Looking at your rules, they look very thorough. I wanted to ask if we considered anywhere in the rules appointing someone to be the custodian of the documents. It sounds like we may do some depositions and some investigations using other outside counsel and so forth. Do we need someone to be responsible for the keeping of the records in the documents as a custodian? I'm not sure if that's needs to be added to these rules or not.
Let me point you to Rule 4 on confidentiality 4C. And it says such procedures may include the designation of a secure location at which members of the committee and others as authorized by the committee can review confidential information and materials. I have in my mind thought about the Secretary of the Senate being the custodian. Mr. Cook, you're present here today. Can I get some feedback from you on that if you're willing to do so? I think I got you activated.
I think that'd be fine, Mr. Chairman.
Use your microphone if you can. Is that number 4? Okay. Go right
That'd be
ahead.
fine, Mr. Chairman. I think either counsel's office or my office, we do keep the records of ethics complaints in our office. But I think either office would be fine. I don't want to speak for the legislative council, but we'd be happy to do that.
Is that agreeable to you, Mr. Leader?
Sounds like a good idea. Thank you so much.
Madam Leader, would that be acceptable to you as well? If we let Secretary Cook be the custodian of any confidential information we receive? I think I got you.
Yes, Mr. Chairman, that would be acceptable.
Well, then that's what I will designate, certainly to begin with, the Secretary of the Senate's office to have a secure location where these can be stored under lock and key. And if that becomes burdensome to you, Mr. Cook, let me know, and I'll talk to Mr. Morelli and consider designating some area in the Legislative Council's office. Thank you. That's a great point, Thank you, Mr. Leader. Other questions from committee members or suggestions? All right. Is there a motion? All right.
But I'd like to make a statement.
All right. I'll recognize the minority leader for statement and then the President Pro Tem.
Did you?
Go right
Okay.
ahead. I think I have you activated.
Well, I'd just like to say that it is my hope that this committee conduct itself in a responsible fashion and pursue the truth, nothing but the truth. I think a political witch hunt or show trial would damage Georgians' faith in both our political and legal system. Our duty as public servants is to strengthen, not weaken, that faith. I commend Chairman Cosset for his openness, his inclusiveness, based on the conversations that we have had. And I thank you for your leadership. And I can't say that I'm looking forward to this, but I appreciate serving, and I want to serve, and I want to be a part of solutions. So thank you, Mr. Chairman, and members on this committee for your service as well.
Thank you, Madam Leader. Senator Kennedy?
Thank you, Mr. Chair.
I hope so. Lord, what I do. I think so.
Okay, there we go. Okay. Mr. Chairman, I want to say publicly how much I appreciate, and I know the other members of this committee do and will continue to appreciate all the thoughtful work that you have put into your service as chairman of this committee. I think you have been very clear, very thorough, and quite frankly, very eloquent about the duties that are on each of the members that are on this committee. What the public doesn't see this morning are the many, many hours that you have spent preparing for how this committee will move forward, how the rules are extremely well balanced and intended to be fair to all. And quite frankly, your approach to this as embodied in the rules and your opening comments about your approach and how you will run this preemptively let us know that some of the concerns that the minority leader just addressed or expressed, quite frankly, you're already operating in accordance with those wishes. And for that, I thank you on behalf of this committee and the work that we will continue to do. Thank you.
All right, is there a motion on these rules for adoption of the rules? I have a motion from the vice chairman and a second from the majority leader. Any further discussion on these proposed rules? All right. In that event, all in favor, raise your hand. And all opposed, a like sign. All right, they are unanimously agreed to and adopted by the committee. We're just had eloquent comments there from the pro tem and the minority leader, but I wanted to open the mics to any other committee member that might have observations, feelings, hopes, wishes, opinions about the work of this committee. I'm happy to recognize anybody else at this time if you have any public comments you would like to make at this initial meeting. All right, I think we've heard it. I will tell you where I think we'll be headed on a time frame is it is going to be the first course of business now that we're authorized to do so to retain staff. Stuart Morelli, I think you're here because you are either appointed by Ms. Howerton or you have agreed to serve as our liaison with the Legislative Counsel's office. I expect one of the first other hires that we'll need to make is to have outside counsel. Although many of us up here are attorneys, I don't feel like it's appropriate for us to be representing the committee in court in the event there is any matter that needs to be litigated. So I will be interviewing potential outside counsel. I encourage and welcome any suggestions from member of the committee of any outside counsel, folks with expertise in these type of matters that you would like for me to interview. We're probably also going to need somebody to help us conduct legal research. I know the Senate Research Office is very overwhelmed at this time of year trying to staff all the various committees and keep them up to speed on all the different bills that are coming through us. So we may need somebody outside to do that, as well as somebody with some investigative experience. I want to encourage anybody in the committee that is aware of individuals that might be well suited to let me know, because we'll be needing to get some assistance here quickly. I would intend to call another meeting of this committee probably within 7 to 10 days at the outside for us to begin our work in earnest. We will be meeting every couple of weeks probably from here on in for a while as we sort through some of these materials. Again, I would welcome the public. If anybody has any information, leads, suggestions, or whatever that you might want to be considered by the committee, to reach out to me or any other member of the committee going forward. And with that, we will be adjourned for the day. Thank you all so much for being here. We're adjourned.